I think we're now ready to resume. Mr. Ewart.
Good morning, my lords. Thank you for that. I was going to say before all the problems arose that I feel rather like a marathon runner who's reaching the stadium, and we're going into the last lap, perhaps, hopefully, of this very lengthy proceedings. Today I am dealing with the issues in respect of which the revenue are the appellant. That is issue 26A, which concerns compound interest, but which in particular now concerns the impact of the decision of this court in Prudential. Issue 10, which is a small issue, but is the appeal on the summary judgments granted by Mr. Justice Henderson in respect of some of the FID claims, and issues 17 and 18, which concern the interaction of tax credits granted to shareholders and the test claimants' actions in unjust enrichment. And what I was intending to do, if that is okay with the court, is to deal with issues 26A and issue 10 first this morning, and then move on to issues 17 and 18. Unusually, we have, in this case, filed two detailed written cases, as your lordships will have seen. I'm not going to attempt, obviously, to cover all of the points in those cases in my oral submissions. As is normal, I stand by everything that's in the cases. What I intend to do is to pick out the key points. So I'll turn then to issue 26A. As you will have seen from the written cases, this issue concerns time value claims. And there are two periods, broadly, to which it applies. First, there is the period which is particular to claims to recover ACT, which has been charged unlawfully. And this arises because ACT could be set off under the UK domestic system against mainstream corporation tax. Also, in some circumstances, the ACT was repaid automatically under the FID regime. Now, this period, the first period, runs from the date of payment of the ACT until the date of set-off or repayment. And as a convenient label, I shall refer to that as the SEMPRA period for obvious historical reasons. The time value for that period can be computed by applying an appropriate rate of interest. And that amount I shall refer to as the SEMPRA amount. So that's the first period. The second period, it runs, in respect of a SEMPRA claim, runs from the time of set-off, date of set-off, to judgment. And for that period, interest runs on the SEMPRA amount as computed. This second period, interest also runs on payments of unlawful tax, which were not set off or repaid. That would be either unlawfully charged corporation tax or unlawfully charged ACT, which was simply never set off. It was surplus when the ACT system was abolished. In that case, the interest runs from the payment of the unlawful tax until judgment. And I shall refer to both of these second periods as the secondary periods. Now that the distinctions I've drawn correspond, you will have seen, to the three periods described in Prudential in the Supreme Court at paragraph 34. It's for your note, that's EF 3535. Now, as regards the SEMPRA period, it was the ratio of the House of Lords decision in that case that there was a claim in unjust enrichment for that period. And that led to a claim for compound interest. However, in SEMPRA, the position was different for the secondary period. And this is because Mr. Justice Park, at first instance, had rejected a claim for compound interest for that period, leaving only a claim under Section 35A of what is now the Senior Courts Act, 1981. Sempra did not appeal against that decision of Mr. Justice Park, and so the House of Lords could not rule on that period, although I think two of the law lords at least gave quite heavy hints as to what they might have done had it been before them. However, that did leave the secondary period as a live issue, even at first instance in this litigation, and of course also in the parallel litigation in Prudential, which was a test claim in another GLO, a parallel GLO, and the case of Littlewoods, which was a claim to recover interest in respect of VAT, which had been wrongly charged and recovered by Littlewoods over a long period of time. Now, we have set out the rather convoluted procedural history of this issue in our first written case at paragraphs 92 to 94. I don't think I need to go into that in detail, but put shortly, the issue in relation to the secondary periods was considered in some detail, first by Mr. Justice Henderson in Prudential. Thereafter, it was considered by the Court of Appeal, subsequently in Littlewoods, and in Prudential in the Court of Appeal, the court pointed out, quite rightly, that they were bound by Littlewoods at that stage to grant compound interest. In other words, that there was a remedy in unjust enrichment for the secondary period. Similarly, in the present case, when the case came before Mr. Justice Henderson at first instance, in the second set of proceedings, the second time round, what's sometimes called the quantification trial, at that stage, it hadn't been decided by any court of appeal, I think it's right to say, and so it was still theoretically open, but it was obvious that Mr. Justice Henderson was going to decide it as he did, in the same way that he had decided Prudential, and that's what happened. So when the appeal reached the Court of Appeal in this case, they were already bound by at least two Court of Appeal decisions in relation to the secondary period and a House of Lords decision in relation to the Sempra period. And so, as you may have seen, the issue was not addressed by the Court of Appeal in this case. Both sides accepted that they had to dismiss the Revenue's appeal on this issue, and the matter was reserved for the Supreme Court. You will have seen maybe you've seen the order. I'll take it you to it later, but the Court of Appeal unusually specifically referred to this issue in their order, although they denied permission to appeal on any issue. They did refer to this issue and to the forthcoming Littlewoods case. Now, again, as I'm sure you're aware, in Prudential in the Supreme Court, Sempra was overruled because it was held that there was no enrichment at the expense of the defendant in cases of time value. In other words, there was no transfer of value from the defendant. And you can see that, perhaps you could just turn it up quickly. Prudential is in Authorities Bundle 2, tab 14. It begins on EF 3546. And it's paragraphs 73 and 79 where the court gives its conclusions. The court just wants to remind itself, paragraph 73 and then paragraph 79. Now, following Prudential, the test claimants accept that the revenue's appeal in this case must succeed in respect of the secondary periods. That is the periods from either the end of the SEMPRA period until judgment or from the payment of unlawful tax until judgment. However, they contend that they ought to be able to recover for the SEMPRA period on the basis of the law laid down in SEMPRA, rather than what we would say is a true position, as now set out in Prudential. And this is said to be on the basis of cause of action estoppel, issue estoppel, or abusive process. But this court has, in giving permission to appeal, also gave the revenue permission to withdraw whatever concession it might have made below in relation to the SEMPRA period. And I do not understand from the written case that the test claimants are challenging that permission before your lordships. I shall refer to this a bit more, but it's already been the subject of at least two sets of objections by the test claimants. So that's the procedural issue. The test claimants' alternative argument is that they have a different remedy which allows them to recover for the SEMPRA period and allows them to go back more than the normal 6-year limitation period. And I shall say something about that after I've dealt with the procedural issues. But I have to confess that I'm still not entirely clear how the test claimants say that they get to that result. So I'll first deal with the procedural objections. Now, just for your notes, we have dealt with the test claimants' various procedural arguments in our second written case at paragraphs 120 to 134. I think it is helpful in this to take matters chronologically and to keep in mind the order in which things happened. And can I just start with the pleadings right at the beginning? So we're starting at the very beginning, I'm afraid, which is 2004 with the original pleadings. And they're all in Appendix Part 2A. The first particulars of claim, dated 16th October 2004, are on page 1041, which is EF 1755. And the relevant paragraph is paragraph 21, which is on page EF 1771. And you can see that that is a claim. Paragraph 21, particularly paragraph 21A, it's a claim in restitution and or compensation for monies paid pursuant to mistake or unlawful demands. And A, the loss of use of monies paid as ACT in the circumstances above to be calculated from the dates of payment until the dates of set-off, etc. And the response to that at that stage, which is a defence dated 27th February 2004, if you just turn up EF 1783, that paragraph was simply at that stage denied. Now, of course, this was before we'd even reached the stage of the reference to the European Court, so very early days, 2004. So the next step was the reference, and you'll find the reference, the first reference of 6 October 2004 in Appendix, it's Appendix 1B, page 733, which is EF 1447. And And you can see the questions that were referred on page 1449 following. And can I just draw attention in particular on page 1450, right at the bottom, paragraph 6, question 6. This is a question in relation to remedies. And essentially the question that was being asked here was which of these remedies are under European law are San Giorgio claims, and which are claims that have to be brought in Frankovich damages. That was one of the early issues, and you can see that Little Roman 4 concerns the claim where ACT has been set up against corporation tax, the loss of use of money between the date of payment and the set-off. So the reference resulted in the first judgment, and that is later on in the same volume. It's page 832. It begins EF 1546. EF 1546 takes you straight to the questions. And can I just perhaps show your lordships briefly the structure of this, because this is also broadly the structure of Mr. Justice Henderson's judgment that we'll see, which followed on from this. So question 1 was the basic question about corporation tax and the situation where the domestic dividends, so a dividend from a UK resident company to another UK resident company, was exempt from corporation tax, the dividend, whereas a dividend from a non-resident company to a UK resident company was subject to corporation tax, but there was double tax relief given. In some cases, for just withholding tax, which is 10% or under holdings, which are called portfolio holdings, and in other cases over that, for the underlying tax on the profits out of which the dividends were paid, and the withholding tax. And so the question was that system, which had a dual system, contrary to Articles 43 or 56. And then question 2 is a question about ACT. And so it was asking essentially whether it was unlawful under EU law to have a system under which, if you received a dividend from a UK company, it carried FII, and with the result that the company didn't have to pay ACT, whereas that didn't happen if you received the dividend from a non-UK resident company. It didn't carry FII. Question 3, I think we can pass over. It's a rather obscure question about surrendering ACT to non-resident companies. And then question 4 was the question about the FID system, whether it was unlawful. The differences in the FID system were broadly twofold. One was the ACT was paid, but it was automatically repaid if it wasn't set off at the first payment of corporation tax. But as a result, the opposite of that was that the shareholders didn't receive a tax credit when a FID was paid. And we might see briefly later on that caused a complaint to the European Court in another case. And then question 5, now that's a question about the standstill provision in relation to free movement of capital. And you may be aware that there is still an issue about the standstill, but not in relation to this, but in relation to question 1, essentially, again, in relation to corporation tax. Just to note that at this stage, we didn't ask a question about standstill in relation to corporation tax. And then question 6 is the remedies question. And as I said before, broadly, it is it is asking the question, how do you categorise these various types of claims that the claimants might have against the revenue? And then there was also a question. There's a couple of questions following on from that, questions 7 and 8. And then question 9 is asking for guidance in relation to factor-tame Frankovich damages as to what was meant by sufficiently serious breach. Now that's no longer an issue because the revenue succeeded on that below, and this court did not grant permission to appeal. So if we just move from that to page 854, which is EF 1569, we can see the answer to the question in relation to interest, to the SEMPRA kind of period. So if the court would just like to read paragraphs 201, 202, and 203 and 204. So if I could just summarize, paragraphs 201 and 203 are dealing with establishing the proposition that it's for national law and the national courts to determine what the remedies are and what the procedures are for recovering tax that has been unlawfully charged contrary to EU law. Paragraph 202 is a statement of the San Giorgio principle. And paragraph 204 is making it clear that the recovery for the SEMPRA period is a San Giorgio claim, that there is a right under EU law, and that is following what was said in Mittelgesellschaft. And that's, of course, why the SEMPRA case had to be brought in the first place, because there was an EU right, and the question was how would that be satisfied in English law. I will come back to the following paragraphs, perhaps when we come to deal with one of the issues, which is an appeal by the test claimants, which is concerns the reliefs which were lost as a result of the unlawful charge to tax. That's paragraphs 205 to 207. So we then had, so following on from this judgment, there was then the first stage of the trial before Mr. Justice Henderson. And before that happened, the pleadings were amended. And perhaps I can just take you to that to see how things stood at that stage. This is the 7th amended particulars of claim, which are dated 13th December 2007. And they're again Appendix Part 2, and they begin at page 1075, which is EF 1789. But it's paragraphs 15 capital A to C, capital C, that are relevant, which you'll find at EF 1812. So that is what the claim in respect to the ACT payments has become now, paragraphs 15A, 15B, and 15C. And the response to that in the amended defence, which is dated 21st December 2007, can take you straight to paragraph 36, which is EF 1851. And it begins, you can see paragraph 36, it's denied that the claimants are entitled to the restitution pleaded at paragraph 15C or any restitution. And then, if which is denied, they are entitled to restitution. It's confined to such ACT as would not have been payable had a deduction been allowed in the amount of the corporation tax levied on the underlying profits in the foreign state, etc. And that's because, of course, at that stage, we're back to a time before the FNR became the crucial thing. And at that stage, it appeared from the judgments that credit was given for foreign tax paid. So that's the position on the pleadings before the first stage of the trial. And then we have the judgment of Mr. Justice Henderson, which you will find in core volume 2. It begins at page 275, EF 989. And you can perhaps see that the structure of it follows to a great extent the structure of the reference. The first part is about the case 5, the corporation tax charge. The problem which had arisen was that the European Court had referred back a question to the National Court for determination. The parties were able to agree the answer to the question, but they were unable to agree at that stage what the question was. So the revenue said the question was one thing and the answer was one thing, and everyone agreed what the answer was, and the taxpayer said the question was different. And that led to a difference of view between the High Court and the Court of Appeal, and resulted in the second reference. So that was dealing with their first section about corporation tax. Then we have Article 56, the third country dividends. So that's what's now the youth point. It's dealing with them in relation to corporation tax. And then we have the ACT issues in relation to ACT, then the FID regime, and then remedies. There is the change of position, which is interposed, and then sufficiently serious breach, and then finally questions about limitation, which your lordships, some of your lordships have seen before they went to the Supreme Court the first time round. Can I then just take you to what Mr. Justice Henderson said about this relevant issue? It's EF 1081. Now, this is all part of a section which was concerned with the categorization of the various claims, either as San Giorgio claims or Frankovich claims, in EU law, and also the question of what remedies there were in domestic law in respect of them. It was being argued by the taxpayers, by the test claimants, that they had a remedy in mistake, in unjust enrichment, in relation to a whole panoply of claims, particular claims in relation to reliefs, loss of reliefs, etc. And so the question was, well, which claims did they have a remedy, and what was the nature of the remedy? And that's what Mr. Justice Henderson was dealing with in this part of the judgment. And if your lordships would just like to look briefly at paragraphs 262 to 264, where he was delineating what he saw as being the scope of the remedy in mistake. And then if you turn over to page 368, if we could just look at paragraphs 267 and 268, where he says something about the ACT claims. Now, paragraph 269, he's dealing with a point which was a live issue then, which was how this all works, where ACT is being paid not at the water's edge company, which is what the European Court were assuming in their judgment, but somewhere much further up the group, possibly right at the top. And those were issues which had to be referred again to the European Court in the second reference. But the reason that he's talking about all of this is because of what he says in paragraph 270. So paragraph 270, he says, further than this, however, as a matter of English domestic law, I'm not at present prepared to go. Consequential steps that were taken within the group to utilise surplus ACT, for instance, by setting it off against unlawful Case 5 corporation tax or by setting it off against lawful corporation tax, increased in amount with a disclaimer of capital allowances, may in principle give rise to a claim for compensation, subject to proof of loss and causation and subject to a sufficiently serious breach being established. But they do not, in my judgment, give rise to a restitutionary claim, because the whole point of those steps was that tax was not paid to the revenue. Any consequential enrichment cannot be seen as a direct result of any unlawful charge. So this was the issue here was between what are the claims that you can bring in unjust enrichment, in mistake, and what are the claims you can't and have to pursue a claim in damages. So that's what this was about. And then you can see the order which followed this. And this is quite important because I think the test claimants place quite heavy emphasis on the terms of this order. This is the order following the first part of the trial. And it's on page 231 of this volume, that is EF 945. It begins on page 945 And the relevant part of the order is on page 947. So these are declarations. I think if you look back on page 945, it begins, it's hereby declared. So number 11, the claimant's claim for compensation and or damages based on the principles set out in San Giorgio extend to the repayment of unlawfully levied tax and to all claims for losses which are a direct consequence of the unlawful levying of tax. So that is his decision in relation to the scope of the San Giorgio claims in EU law. And then in Declaration 13, he says the claims for unlawfully levied ACT referred to in paragraph 11 and paragraph 12 to the extent it's concluded that community law has been breached in those circumstances. Those were the other circumstances I was referring to that were subject to a reference. Would, as a matter of English law, fall within the proper scope of a mistake-based restitutionary claim, which mistake continued to be operative at the time the payments were made. And then there is an order. Paragraph 1 of the order deals with this. However, this was changed, amended on appeal by the Court of Appeal. And so you really need to look at what they did, which is on page EF 717. Which is the order of the Court of Appeal following the appeal at the second stage. And it's page EF 717, paragraph 16, order 1, that is order 1 in Mr. Justice Henderson's order, is varied to read. And then you can see what it now says. Following claims are successful. Claims for the repayment of surplus ACT or the time-valued ACT, either utilised or refunded, paid on or after 1st January 1973 by claimants which received dividend income from subsidiaries established in other member states, so far as the ACT paid was not due after taking into account the tax credit under 231, respect to those dividends, and the claims are made within the applicable limitation period. And the same for B in relation to third country FIDs. So just going back to Declaration 13 on page 947. We say that's simply a declaration that states the obvious, that any unlawfully levied ACT can, in the proper circumstances, fall within the scope of a mistake-based claim. So if you've paid unlawful ACT by mistake, you're within the scope of a restitutionary claim, and the mistake continued to be operative at the time the payments were made. It's not saying anything about the nature of the cause of action or the scope of the cause of action in mistake, which was a matter, as we shall see, which was set down to be determined at the second stage of the proceedings. So following this judgment, there was
by implication, I think he must be meaning that the claims for losses referred to in paragraph 11 don't fall within the proper scope of a mistake-based restitutionary claim.
Yes, but he's certainly not deciding they do. Yes, that's right. Yes, my lord. Yes, there is a distinction exactly in 11 between the repayment of unlawfully levied tax and losses which are a direct consequence.
Yeah, and that's completely orthodox, that restitution isn't a loss-based remedy.
Yes. Yeah. So, following on from this judgment, there was an appeal to the Court of Appeal, and there was a subsequent appeal to this court on some of the issues. But what actually happened, you may have seen, those who were considering permission to appeal at the time in the Supreme Court decided to kick the can rather far down the road in relation to some of these issues. So permission was granted on some issues, particularly limitation questions, which we have the judgment, and we will come back to that later on. And there was a reference to the European Court in relation to the limitation issues, Section 320. But quite a number of the issues were simply parked, and in fact, I think at least two of them are now before this court in this hearing. The youth issue and the issue in relation to management expenses and group relief. These were all part of the appeal in the first stage, which are now finally being heard. So following on from that, there was a further reference, the second reference, and you'll have seen that. I'll come back to that in the context of some of the other issues. I don't think I need to take you to it now, but the decision of in the second reference, it was decided that there should have been granted a credit at the foreign nominal rate of corporation tax, or at least that would have been proportionate and justifiable as a method. Whereas it wasn't. It was a restrictive, discriminatory measure to exempt dividends from domestic companies and tax them, although subject to double tax relief, from foreign companies. So that resulted in the second set of part of the proceedings. And again, the pleadings were amended following that reference and before the second stage of the trial. And you can find that was the 13th amended particulars of claim, which were dated 5th of June 2013. Again, in Appendix 2A. And they begin at EF 1876. And it's paragraphs 15A and 15B, which are on EF 1897. And this, again, deals with the ACT claims. So 15A, 15B, and 15C. I think they're much in the same form as they were in the 7th amendment that we've just seen. And then the defence, the re-amended defence, which is dated 11th February 2014, and the relevant paragraph are paragraphs 30 to 35, which are on EF 1925. And if you look at paragraphs 31, 32, 33, and 34, you'll see the response at that stage. And you can see in particular paragraph 33 What's a distinction between the unlawfully levied tax and the claims and mistake? And there is an admission in relation to the unlawfully levied tax, but there is a denial in relation to the claims for mistake.
Can I just ask, was that because of an argument about change of position, or for some other reason?
No, because change of position is dealt with as a defence.
Oh.
It was because there was still a number of issues. One of them is still before us as to the enrichment of the defendant.
I see.
But I think the point to make is that certainly as matters stood before the second stage of the trial, there's no formal admission in the pleadings, as far as that's of any importance, in relation to mistake claims for time value.
Yeah. I'm sorry, I was misreading this. I see you were accepting that there was a restitutionary claim based on the receipt of the money, but not one based on its retention.
Yes, exactly. That's right. Yep. Which is the distinction I think is made in Prudential.
Yeah.
Between the yeah. So that's how the pleadings stood at that stage. And we would say these issues were the issues as to the Sempra period were clearly still open when Mr. Justice Henderson came to hear the second stage. You'll find his judgment in Core Volume 2. It begins at page 566, EF 1280. But I can take you, it's a long judgment. I can take you immediately to paragraph 264, which is EF 1353. And you can see how he then deals with issue 17. That's at the bottom of page 1353, 264. He says, this question focuses exclusively on the position under English domestic law. Well, you'll have seen now that it's been widened out to include European law. The gist of which is that the revenue were not enriched for the receipts of unlawful ACT. So he then says in 265, leaving aside the tax credit argument, the position in my judgment is as follows. And then he says the revenue were clearly enriched by the monetary value at the date of receipt of the unlawful sums, case 5 tax and ACT paid in money. And in 267, having cited some authorities, the claimants are prima facie entitled to recover the face value of the principal amounts of unlawful case 5 tax, unutilised unlawful ACT. And then 268, secondly, the revenue were also enriched for the time value of the use of the money paid to them in the case of the unlawful case 5 tax and unutilised ACT from the dates of payment till the eventual repayment. And he cites there Sempra and portfolio dividends number 2, which is in fact Prudential at first instance, and Littlewoods. And then thirdly, he says, I also consider the revenue were enriched for the time value of the continuing benefit arising from utilised ACT from dates of utilisation until the dates of eventual repayment. And that's relying again on himself in Prudential and Littlewoods. And then in 270, as Lord Hope noted in Sempra, referring to Professor Burke's, the same point was made by Lord Nichols. In considering the extent of the revenue's enrichment in respect to the time value claims, Important and difficult questions therefore arise about the basis on which the enrichment should be ascertained and the availability both in law and in the facts of the principle of so-called subjective devaluation. I will deal with these questions in detail when I come to the issues relating to change of position, etc. And then 271, so far as the law is concerned, I've already considered many of the questions at some length in Prudential and Littlewoods, and he's analysed the speeches in Sempra, etc. He says, my ultimate conclusion in each case was that the correct common law measure of the revenues enrichment under claims to recover the time value of unlawfully levied tax is the objective market value of the use of the money in the hands of the revenue, represented by an award of compound interest on the conventional basis adopted by the majority in Sempra. To anticipate, my ultimate conclusion in the present case will be of similar nature. So then, and that's what he did conclude. And then he said, that being the general position, how is that affected by the revenues argument about tax credits? Then he goes on to deal with, I'm not going to go into that now. He goes on to deal with tax credits. And this is reflected in his order, Mr. Justice Henderson's order, made following the quantification trial, which you find it begins on page 246 of this bundle. That's EF 960.
Mr. Ewart, if you could just pause for a moment. We lost Lord Hamden for a moment.
All right.
I think he just needs direction.
So, sorry, Lord Hamden, I was just referring to, it's page EF 960, Mr. Justice Henderson's order. And it's in particular on page EF 969. Where it begins at the bottom, 22, the answers to issues 22, 23, 24 are, and then the actual benefit argument is not available under English law. Even if it were, it's rejected on the facts, and it's not available under EU law. And then 23, issues 25 and 26A are answered as follows. The restitution to which the claimants are entitled has three main elements. One, restitution of the full amount of the principal sums. Secondly, they're entitled to restitution of the time value of the prematurely paid ACT from the dates of payment until the dates of utilisation. And it's common ground that these are measured by compound interest. Third, restitution of the time value of the amounts recoverable under each of the above headings from the dates of payment or the dates of utilisation until the date when restitution is made. So you can see that Little Roman 2 is the Sempra period, is his declaration in relation to the Sempra period, and Little Roman 3 is his declaration in relation to the secondary periods. And he then says the measure of the time value claims measured by compound interest. And we can then see that permission to appeal was granted in relation to various of these declarations, and you find that beginning on page 973, paragraph 9, the defendants are granted permission to appeal against the following declarations. And if you go over the page, M is declaration 22 and N is declaration 23, issues 25 and 26A. So it seems quite clear, we would submit, that Mr. Justice Henderson made these declarations, made these decisions in the second stage of the proceedings and granted permission to appeal against it. Now, we know that the Court of Appeal didn't hear any argument on the time value issues because they recognised that, everyone recognised, they've already been determined by the Court of Appeal in Littlewoods and then followed by the Court of Appeal in Prudential. However, it did mention the issue in its order. If you just turn back to EF 842, this is the end of the. If you look on the previous pages, you'll see this is the order of the Court of Appeal following their judgment in the second stage, and they say in paragraph 6, permission to appeal to the Supreme Court refused. Note, the court's blanket refusal should not be taken as indication that it does not consider any of the points raised worthy of consideration by the Supreme Court. And on issue 26A, HMRC should be entitled to take advantage of any success they may have on this issue in the pending Littlewoods appeal. But then they say it's important that the Supreme Court should be able to manage its own affairs in relation to these complex issues. In fact, in Littlewoods, the Supreme Court didn't reach, I think my Lord Reid, maybe, Lord Hodge, I think, maybe aware that it didn't reach this issue because it decided in favour of the revenue on earlier parts of the decision. So it didn't have to consider this point. And it was, in fact, prudential in the Supreme Court where the point was actually considered and decided. But that's why there's a reference to Littlewoods in here. So this court, we have permission to appeal against 23. I'm sorry.
My recollection is that it may be relevant to mention that we did consider in Littlewoods an argument that EU law required the payment of compound interest, and we rejected that argument.
Yes, you rejected that argument, and then you also considered whether Section 80 and Section 78 excluded remedies in the unjust enrichment as a matter of English law, and decided they did, and that of course left the claimants with no remedy because they didn't have a European right and they didn't have an English law right. But if you had decided that they did potentially have an English law right, you may have had to go on to consider this question.
Yes. Well, we didn't leave them without a remedy. You said that the remedy they had was the one that Parliament had prescribed.
Yes. And they had a remedy for various periods, but not for particular periods. Yeah. Yes, that's right. And of course, it was important because when these decisions were being reached by Mr. Justice Henderson, you'll appreciate, at first instance, and indeed by the Court of Appeal, the position that had been decided at that stage was, in Littlewoods, was that European law did require compound interest. You may remember that. So that was the context in which these decisions were being made. So we actually required two parts of the jigsaw. One was the revenue had to win the point in Littlewoods that compound interest wasn't required by EU law, and they also had to succeed on the domestic law point there, that it wasn't provided by domestic law. There was two stages to it.
The European Court had said that domestic law had to provide an adequate remedy, and the lower courts had taken the view that anything short of compound interest was not an adequate remedy. But we took the view that simple interest at the statutory rate was an adequate remedy.
Yes, that's right. Yeah. But as I say, if you hadn't taken that view, then of course, whatever the English law position was, perhaps a remedy would have to have been fashioned for compound interest somehow. So as I say, we needed both parts of the jigsaw. So we would say what I've shown you really is a short answer, or not perhaps short, but an answer to the test claimant's arguments on jurisdiction and cause of action estoppel, and also an answer to their reliance on Henderson abuse. We would say it cannot be an abuse of process to litigate an issue which has been agreed between the parties as an issue at this stage of the litigation, and which has been the subject of an appeal or two appeals with permission. So I'm now going to turn to the estoppel and the abuse arguments in more detail. I'm sorry, my Lord Hodge.
I just wanted to pick up on one point. I mean, what was reserved for appeal was the question of the rate of interest. what was not challenged, and it isn't before us, is that the courts below held that there was a restitutionary claim for the time value of money. Are you not stopped from arguing that there is one? There isn't one.
Well, what was an issue on one level was there compound interest or not? But behind that was the question, what was the basis of recovery? Yeah. Because the only way in which the claimants could recover compound interest was by establishing that they had a claim in unjust enrichment for both the Sempra period and for the secondary periods. That was the basis of Mr. Justice Henderson's decision. So what we were appealing, as in Prudential, what we were appealing was his decision that there was a claim in unjust enrichment for those periods. Because if there was, then they were entitled to compound interest. If there wasn't, then there wasn't any other base. Well, we would say there isn't any other basis on which they were able to claim compound interest. So,
but what
that was the result? I agree with the Lord, but
would the logic be if there wasn't a claim for compound interest because there wasn't a restitutionary claim, there was no claim at all for the time value of money? Once the money had been repaid.
That's right, and so as regards the secondary periods, certainly, and this is accepted, the only claim which the claimants would have would be the normal claim under Section 35A of the Senior Courts Act, which is the claim that you normally have where there's been debt or damages awarded. You can claim under Section 35A, but they wouldn't have any common law claim for that period.
Well, if they had no common law claim for the Sempra period, how does issue 26A, which says is it compound or is it simple interest, how does that amount to a challenge to the finding that there was a restitutionary claim in respect of that period? Are you not stopped from at least arguing that?
Well, I think maybe what you're looking at there is what the issue says, or the summary of the issue, as opposed to what the actual legal arguments were. But so what we were challenging was the proposition that there was a claim in unjust enrichment.
And you say that was open to that. You say that was still open to us to consider now.
Yes, as it was in Prudential.
Thank you.
Yes. Well, I say that because I'll develop it in more detail, but because this issue was actually under appeal. Now, it is true, of course, that in the lower courts, it wasn't open to us, at least before Prudential, to argue that there shouldn't be any interest for the Sempra period, because that had been decided by the House of Lords. All the courts were bound by that decision. But it wasn't the case that it wasn't under appeal, I would submit.
Thank you.
Can I start by then going to the Virgin Atlantic case, which is probably the most recent authoritative analysis of this area?
Can I pursue, Lord,
yeah,
a little further? In this issue, this point is put before us on appeal from the first Court of Appeal, the order following CA1 rather than CA2. Am I right or am I wrong in thinking that?
No, it's an appeal from CA2.
From CA2, I see.
Yeah, and it was in CA2 that these issues were considered.
Right. Oh yes. Right. Okay.
Yeah.
Thanks.
So can I take you to Virgin, which is in the second authorities bundle. It's tab 16. It begins on EF 3674. I don't know whether your lordships are I'm familiar with this case or the facts. It's slightly odd circumstances arose. You can either, if you look at the head note, you will see what happened is that there were parallel proceedings. So the claim was brought and went through the English courts. And it was decided by the Court of Appeal on the basis that the patent existed and was valid. However, and I think the point was that the Court of Appeal's order on that had been perfected, so that Court of Appeal had no further jurisdiction. Subsequent to that, it was held in the parallel proceedings in the EPO that it was invalid, in fact. Then an application was made to the Court of Appeal. And you can see that I think the best way to look at it actually is on page 3656, which is the procedural history. And you can see in the paragraph beginning just above F, the Court of Appeal allowed the appeal on the basis the patent was valid and infringed and refused the defendant permission to appeal. The defendant applied for a stay. That was refused. They declared the patent valid and infringed and directed an inquiry to damages. Following the decision of a technical board of appeal of the EPO to amend the patent by deleting as invalid all the claims which the Court of Appeal had found to be infringed, the defendant applied to the Court of Appeal to vary its order, and the Court of Appeal refused. So it was against that refusal to vary its order that the appeal came to the Supreme Court. And the question then was, well, how should this be dealt with when there was an inquiry for damages in relation to a patent that the English courts have declared to be valid, but the EPO is declared to be invalid subsequently? And you can see that the issue is summarised in Lord Sumption's judgment at paragraph 16. He says on page 3672, the fundamental question is whether Zodiac is entitled to contend on the inquiry as to damages that there have been no damages because the patent has been retrospectively amended so as to remove the claims held to be infringed. This depends on whether the Court of Appeal was right to say that its order declaring the patent to be valid continued to bind the parties at rem judicatum, notwithstanding that the patent was later amended on the footing that it was not valid in the relevant respects. And then he goes on in the next paragraph to consider the general principles of res judicata, which he says is a portmanteau term which is used to describe a number of different legal principles with different origins. Just moving over paragraph 17, where he sets out various of the historical principles. He says in paragraph 18, it's only in relatively recent times that the courts have endeavoured to impose some coherent scheme on these disparate areas of law. Starting point is the statement of principle of Vice-Chancellor Wigram in Henderson. And then he then quotes from Henderson. But if we then move on to paragraph 20, the implications of the principle stated in Henderson were more fully explored by the House of Lords in Arnold. And then he then describes the Arnold case, which was a case where there had been a rent review and an appeal from the arbitration to Mr. Justice Walton, who had construed the rent review clause in a particular way. He then refused permission to appeal, and under the rules in relation to arbitrations, there could be no further appeal where the judge refused permission. And so subsequent to that, a number of cases cast serious doubt on whether Mr. Justice Walton was right in his interpretation of the rent review clause. And then in the next rent review, it was contended the party couldn't challenge the decision of Mr. Justice Walton because a cause of action estoppel arose, even though it appeared quite clearly that he got the law wrong the first time round. And it was decided in the end that they could challenge it. And in particular, because in those circumstances where the law had been seen to either change or at least be perceived to have changed after his decision. And then if you look at the bit below the quote at letter F, the case before the committee was treated as one of issue estoppel because the cause of action was concerned with a different rent review from the one considered by Mr. Justice Walton. But it's important to appreciate that the critical distinction in Arnold was not between issue estoppel and cause of action estoppel, but between a case where the relevant point had been considered and decided on the earlier occasion, and a case where it had not been considered and decided, but arguably should have been. The tenant in Arnold had not failed to bring his whole case forward before Mr. Justice Walton. On the contrary, he'd argued the very point which he now wishes to reopen and had lost. It's not therefore a Henderson case. The real issue was whether the flexibility in the doctrine of res judicata, which was implicit in Vice-Chancellor Wigram's statement, extended to an attempt to reopen the very same point in materially altered circumstances. Lord Keith, with whom the rest of the committee agreed, held that it did. And then Lord Keith considered the principle of res judicata extended to every point which properly belonged to the subject of that litigation, in which the parties exercising reasonable diligence might have brought forward at the time. He regarded this as applying both the cause of action estoppel and issue estoppel. Cause of action estoppel, as he pointed out, was absolute in relation to all points decided, unless fraud or collusion is alleged. But in relation to points not decided in the earlier litigation, Henderson and Henderson opened up the possibility that cause of action estoppel may not apply in its full rigour, where the earlier decision did not in terms decide, because they were not raised, points which might have been vital to the existence or non-existence of the cause of action. And then if you just pass down to letter D, the relevant difference between the two was that in the case of cause of action estoppel, it was in principle possible to challenge the previous decision as to the existence or non-existence of the cause of action by taking a new point which could not reasonably have been taken on the earlier occasion. Whereas in the case of issue estoppel, it was in principle possible to challenge the previous decision on the relevant issue, not just by taking a new point which could not reasonably have been taken on the earlier occasion, but to re-argue in materially altered circumstances an old point which had previously been rejected. And then going down to paragraph 22, he says Arnold is authority for the following propositions. 1, cause of action estoppel is absolute in relation to all points which had to be and were decided in order to establish the existence or non-existence of a cause of action. Cause of action estoppel also bars the raising in subsequent proceedings of points essential to the existence or non-existence of a cause of action, which were not decided because they were not raised in the earlier proceedings, if they could with reasonable diligence and should in all circumstances have been raised. Except in special circumstances where this would cause injustice, issue estoppel bars the raising in subsequent proceedings of points which were not raised in the earlier proceedings or were raised but unsuccessfully. If the relevant point was not raised, the bar will usually be absolute if it could with reasonable diligence and should in all the circumstances have been raised. It was submitted on behalf of Virgin that recent case law has recategorised the principle in Henderson and Henderson so as to treat it as being concerned with abusive process and take it out of the domain of res judicata altogether. And then he goes on to say in 24, I don't accept this. The principle in Henderson and Henderson has always been thought to be directed against the abusive process involved in seeking to raise in subsequent litigation points which could and should have been raised before. And there was nothing new or controversial about it. And then could I should pass on to paragraph 25. And could you perhaps the court just read paragraphs 25 to 27? Can I just then be clear what we say the issue is in this case in relation to cause of action estoppel, issue estoppel, and Henderson? We say it can only be argued on the basis that something was decided at the first stage in this litigation. That is the first stage before Mr. Justice Henderson, and then the Court of Appeal, and then the Supreme Court. And that whatever that was decided, raises an estoppel of one of these sorts. I say that because anything that was decided in the second stage of the litigation is still under appeal. It was appealed to the Court of Appeal, and it's being appealed to this court. So it can't be, there can't be any issue estoppel or cause of action estoppel in relation to matters that are under appeal. I think that's probably obvious. So I think the argument here has to be something was decided at the first stage, and that, whatever that is now binding by reason of either cause of action estoppel or issue estoppel or Henderson abuse of process. And we say that there was nothing decided. We say primarily there was nothing decided at the first stage. There was nothing decided about a cause of action. But even if there was, the core principle in relation to cause of action estoppel is that the determination at a previous stage or in previous proceedings is binding in relation to all points which had to be and which were decided at the previous stage. So putting it in context, if the point had been raised at the previous stage, that in relation to the Sempre period, there was no recovery in unjust enrichment because there was no transfer of value. They weren't enriched at the expense of the defendants. If that had been raised and decided by Mr. Justice Henderson and hadn't been appealed, then of course that would have amounted to a cause of action estoppel. But that's not what happened, we would submit, in the previous stage. None of these points were raised or decided.
Can I ask Mr. Ewart?
Yeah. Yes.
The dicta you're taking us to are all concerned, I think, with the significance in subsequent proceedings of matters decided in earlier proceedings. Are there authorities concerned with the operation of these principles within a single set of proceedings where issues have been addressed in stages?
Apart from your own decision in relation to the mistake,
yes.
I think all there is, I think, is that there is one Court of Appeal case, I'm afraid whose name escapes me, where it is recognised in principle that there could be an estoppel in relation to different stages in litigation, in one piece of litigation. But I don't think there's any case which actually considers how that works in practice.
Thank you.
Lord Hodge.
Are you referring to the case of Fidelitas?
I think that may be right. Yes.
Which is quoted, I think, in Arnold.
Yes.
Yes.
Yeah. I'll check that, but yeah, I think that's right. But I don't think from memory that there's anything more in it than a recognition that it is possible. Tanu. Yes, I'm told there's also a case called Tanu where I think it may be mentioned. But there's certainly nothing anything like this litigation. And of course the context, I think, as it was recognised in your previous judgment in relation to limitation, is a case in which there were a myriad of issues which had to be determined. And some of them were determined at the first stage, and some of them, as it happened, were determined at the second stage.
Lord Keith looks at Fidelitas in Arnold at EF 3249.
Yes.
It's talking about something being done in stages in the same suit, and you can't go back and reopen things saying they were wrongly determined.
Yes. And I would certainly accept in principle that must be possible. If you have proceedings in a case determined in different stages and something becomes final and has been decided, then it would be strange if you could simply reopen it in subsequent stages of the same litigation. That's subject to the point, of course, that's made in Virgin about quantifying claims on a false basis. What they were saying in Virgin at the end was, well, what Lord Sumption seemed to be saying was, well, although the Court of Appeal had decided the patent is valid, we now have to determine the quantification of the damages. And we can't do that on a false basis. We can't do that on the basis the patent is valid. And that's not a breach of cause of action estoppel or issue estoppel to then decide that issue on the basis of the true position. That's what the Supreme Court said in Virgin. And that's why they said, well, the damages would be assessed at nil, essentially, because there isn't anything to breach, in truth.
Mr.
Yes, sorry, Lord Briggs.
You are therefore, I think, drawing an analogy between a case like Virgin, where there is a subsequent change in view about the legal consequences of something with retrospective effect, so as to undermine the very basis of the court decision, based as it was on the validity of the patent. And this situation where there's been, as between Sempra Metals and Prudential, what I suppose you would characterize as a change in the law relating to interest so far as concerns the Sempra period.
Yes. Yes. Can I just make it clear, though, that this is not my primary argument in relation to cause of action estoppel and issue estoppel. Our primary argument is that there is nothing to found the estoppel on in the first place. But my fallback position, our fallback position would be, even if that is the case, we would say when it comes to quantifying the restitution, as in Virgin, it wouldn't be right to quantify on a false basis, where exactly the law has changed retrospectively in between. But can I just get back? My primary position is that when one looks at what happened in the first stage, there wasn't any determination of a cause of action in unjust enrichment, in mistake, in respect of the Sempra period. And even to what there was, and you'll find this mentioned in the judgment, was a recognition that at that stage, Sempra was the law. But we say even if there was, in some sense, a determination of a cause of action, there wasn't a determination of these points. And that's a distinction that's drawn in Virgin. In Virgin, it said, in relation to cause of action estoppel, if there has been a determination of the points below, then you're bound by it, even if the law has changed. The position seems to be different in issue estoppel. It seems to be more easier in issue estoppel if the point's been decided, but the law has then changed, or circumstances have changed, including a change in the law, that it wouldn't be binding. But as regards cause of action estoppel, Lord Sumption's point is, it's only if the point has actually been determined and raised, then it would be binding in subsequent proceedings, or subsequent parts of the same proceedings. And we say in this case that certainly didn't happen. There was no determination of the issue, which is the issue which arose in Prudential at the first stage in FII. I've shown you what Mr. Justice Henderson said, and I've shown you, most importantly, the order that he made. And in none of that is there a determination, a binding determination of the cause of action arose under English law in unjust enrichment for the Sempra period. I think we've lost Mr. Bremner.
Just to wait while we try to see if Mr. Bremner rejoins us.
I'm very similar. I can still hear you all, although all of the videos suddenly went off. But they're now back. I don't know quite what happened.
We can both see and hear you, Mr. Bremner.
I'm very grateful for that.
Thank you.
Mr. Ewart, really your point boils down to this, does it not, that at paragraphs 11 and 13 in the order in the first stage, you say that those paragraphs don't amount to a determination of the issue. Is that
in relation to time value claims?
In relation to time value claims?
Yes.
Yes. So that's that's EF 947. Yes.
Yes.
Okay. Thank you.
Yep. And they don't, even if you link them to the order as amended by the Court of Appeal, they still don't determine that these claims in unjust enrichment and mistake, that they exist. So that's my first point. My second point is that even if there is a bare determination of a cause of action, in a situation where the points that we're now, well, the point that was raised in Prudential wasn't raised and decided, then cause of action estoppel wouldn't run. And then the third point is, as Lord Briggs said, even if that is wrong, on the quantification, it wouldn't be right to quantify on the basis of a wrong view of the law. I think as far as the standing back and looking at the merits of this is concerned, there can be no doubt we would submit that this was not an issue at the first stage. And in particular, if I could just point out some other facets that weren't being decided at the first stage. Issues 17 and 18, which I'm going to come on to this afternoon, were clearly not determined at the first stage. They're being determined at the second stage. And they're an integral part of the cause of action in unjust enrichment. In other words, was there an enrichment at all? Was there an enrichment at all in circumstances? And if there was no enrichment to begin with, then there wouldn't be any cause of action. Also, another point that was reserved to the second stage was the question about benefit, actual benefit. you'll have seen that it was an issue before Mr. Justice Henderson and before the Court of Appeal. It's no longer an issue now. But the question was, in relation to time value claims, what was the actual benefit, and should that be the measure of the time value claims? And then finally, of course, what was also clearly reserved to the second stage was the rates of tax, sorry, the rates of interest that should be applied, and the rests and things like that. So all of that was part, as you've seen, of the second stage of proceedings. So it's actually quite difficult to know what exactly was determined, what the case claimants would say was determined at the first stage. Really, we would say all that was determined was the availability of a remedy at a very high level of generality. And of course, it was recognised that a remedy had to be available of some sort, because that's what EU law demanded. Can I then just briefly deal with Henderson abuse of process, because that's a distinct and different ground, but that is very much based on the evaluation of the merits and whether it is an abuse to raise the point at this stage. And can I just mention some further relevant considerations? First of all, at all times, as you've seen, the revenue have formally denied liability for the Semper period in the pleadings. Secondly, it was an issue which was tied up intimately with the issue of the restitution for the secondary periods. And that was an issue that was determined even at first instance in the present case and in the Court of Appeal, because it was, as I explained, it was still left open by Sempra, and was clearly not an issue to be determined at the first stage. And indeed, what happened in Prudential was, I think the court realised that the logic of the position of the argument in relation to the secondary periods led to the conclusion that the decision in Sempra was wrong. Then thirdly, as I've already mentioned, the questions of recovery for the Sempra period involved a number of issues which had clearly been reserved for the second stage. As I say, the enrichment issue, issue 17, the value of the benefit issue, and the rates of interest. The test claimants didn't object to these issues being determined in the second stage, and all of this was enshrined in a specific declaration made by Mr. Justice Henderson, which covered both the Sempra period and the secondary periods, which is under appeal to this court. And fifthly, we would say there's no prejudice to the test claimants, apart from the possibility of losing the point, obviously. It had been argued successfully. If we just look at the history, it argued successfully before Mr. Justice Henderson in Prudential that the test claimants could succeed in unjust enrichment for the secondary periods. And they then unsurprisingly argued the point before Mr. Justice Henderson in these proceedings, and they were successful. The total judgment given by Mr. Justice Henderson was close to £1.2 billion for companies in the back group. Of that amount, the difference between simple interest under Section 35A and compound interest for the secondary periods alone ran into hundreds of millions of pounds. I think for BAT alone, it was over £500 million was the difference. Any suggestion that the test claimants might not have pursued that claim before Mr. Justice Henderson, if they had realised that Sempra might be reversed on appeal by the Supreme Court, we would suggest is fanciful. And of course, after they had succeeded before Mr. Justice Henderson, it was the Revenue who appealed the matters to the Court of Appeal and then to this court. So it can't seriously be argued that anything different would have happened if the claimants had realised, as I say, that Sempra might be reversed. Finally, just briefly, permission to withdraw the concession. This was given after, first of all, the test claimants objected to it in their written submissions, and then they also argued against it at the oral hearing for permission. But the permission was given both after the first stage and after the second stage of permission. And as I said, I don't understand at this stage that the test claimants are challenging that. So if it's simply looked at, as we say it should be, as a question of whether a new point can be raised, which couldn't be raised below, and which the Revenue's concession simply amounted to a recognition below that they couldn't argue the point, then we would say that's the end of the matter. So that's what I was proposing to say, unless there's any more questions from the court about the procedural issues at this stage. What I was going to deal with now briefly is the remedy for the Sempra period. And we've dealt with this in our first written case at paragraphs 95 to 99. And our submission is simply that there is a remedy given by Finance Act 2019, sections 85 to 86 for this period. And you'll find that in Authorities 1, tab 2, EF 3053. And this was a provision which was introduced after Prudential, when it was recognised that there was at least a considerable doubt as to whether any remedy existed to satisfy the claimant's San Giorgio claims in relation to the Sempra periods. And what it provides for is anyone who brought proceedings before 12th December 2012 with a claim arising out of a relevant payment, which is defined in 2 as a payment of unlawful ACT made on or after 1st January 1986, or in the period of 6 years immediately before the date proceedings were started. You're all back. Sorry, you disappeared for a moment from my screen. And in subsection 3...
Mr. Ewart, I wonder if for those who, most of the panel were not involved in Prudential, it might be worth just explaining it in a few sentences what was actually decided in that case about interest. I mean, as I recollect, the court first of all did not question what had been said in Sempra about damage claims.
Yeah.
So in other words, it didn't question the decision in Sempra that where you had a claim for compensation for loss, that might require an award calculated on the basis of compound interest. But insofar as the claim was based on unjust enrichment, the restitutionary, the overpayment of the tax gave rise to a debt, because the obligation, the overpayment results in an obligation under the law of restitution to make restitution of the undue tax. And because there's a debt, it follows that the debt would carry interest. And it's in that way that the time value of the money, which ought to have been paid by the recipient of the undue tax to the taxpayer, is remedied. Is recognised as remedy. But the problem that Prudential didn't decide, because it wasn't an issue in the case, was what happened where there was no action for repayment of the undue tax, and therefore Section 35 of the Court Act didn't apply, because those payments had been dealt with by a set-off or some other way which didn't require the money to be repaid.
Yes, that's right, my lord. That was, sorry, I took the quote earlier to paragraph 73 and 79. I mean, which seemed to be the summary of I think what you said, and it's correct, because I think the court did comment that I think it's in paragraph 78, in fact. At the very end of paragraph 78, it's unnecessary to decide in this appeal how an award of interest should be made available in those circumstances, but there were a number of potential solutions. That's the point that was left open, exactly. Yeah. And that's the point I think I'm addressing now. But of course, at this stage, section 85 and 86 didn't exist at the time of the Prudential decision.
And obviously, Mr. Aronson and Mr. Brebner are putting forward an alternative solution.
Yes.
Well, that's a number of alternative solutions.
Yes. Yeah. Yes. But anyway, what just to get this out, what you say first of all is that Section 85 does provide a remedy, as Lord Reid suggested. Obviously, a damages claim provides another possible remedy, as recognised in Sempra. And what this provides for is a remedy which gives you interest for the period, the Sempra period, at prescribed rates, and then similarly interest for the secondary period after that at prescribed rates. But what it also makes clear in Section 86, subsection 2, is that this is not intended in any way to be an exclusive or remedy. So if there is another remedy available and it can be identified, then it's still available. That's 86 subsection 2. So that does lead on to the question, well, what other remedy could there be? I'm just noting the time, my lord. I was going to now move on to consider briefly what that remedy might be.
Yes, and presumably you're going to deal with the position in relation to payments made before the 1st of January 1996.
Yeah, well, the position of, yes, as to whether there is a remedy or not.
Yeah.
Yes. Yeah. So.
Okay. Well, in that case, we'll adjourn now and resume at 2 o'clock. Thank you very much.